If you are a green card holder living in the United States right now, I need you to stop whatever you are doing and give me your full attention for the next several minutes because a brand new U.S. immigration law was officially signed into effect today, and the changes it brings for lawful permanent residents are the most significant we have seen in over 2 decades. This is not speculation. This is not a proposal still working its way through Congress. This is law effective immediately. And if you do not understand what it means for you, you could be putting your green card, your ability to become a citizen, and your entire future in America at serious risk. My name is James. I have been a senior U.S. immigration professional for 6 years, and through Immigration News Today, I have made it my responsibility to ensure that you are never caught off guard by changes like this. Stay with me until the very end of this video, because what I explain today could protect everything you have worked so hard to build in this country. Let me begin by speaking directly to the emotions I know many of you are experiencing right now when you hear that a new immigration law has just been passed, one that specifically affects green card holders. Your heart probably sinks. You feel anxiety, maybe even fear. You wonder if your status is still secure. You wonder if the rules you have been following for years have suddenly changed. You wonder if you need to take immediate action, or if you can simply continue living your life as before. I understand all of these feelings completely, because I speak with people like you every single day, but I want you to hear me clearly. Today is not a day for panic. Today is a day for clarity, understanding, and preparation, because while this new law is indeed strict, it is not impossible to navigate. If you understand the changes and follow the right steps, you will be absolutely fine. As of date, the President has signed into law what many are calling the most comprehensive immigration enforcement and compliance legislation. Since the Immigration Reform and Control Act of 1986, this law passed both the House of Representatives and the Senate after months of intense negotiation, and it has been widely reported by every major credible news outlet: Reuters, the Associated Press, the New York Times, the Wall Street Journal, and BBC. The official title of the legislation is lengthy and technical, but what matters to you as a green card holder are the 5 major provisions that will directly affect your status, your rights, and your obligations starting in 2026. Let me walk you through each one in plain, simple language so there is absolutely no confusion about what this means for your life. The first major change relates to continuous residence and physical presence requirements under the previous rules. USCIS had considerable flexibility when evaluating whether a green card holder had truly maintained the United States as their permanent home. You could travel abroad for up to 1 year, sometimes even longer with a reentry permit, and still maintain your lawful permanent resident status. That flexibility is now dramatically reduced. The new law establishes that any absence from the United States of more than 180 consecutive days, that is approximately 6 months, without prior approval in the form of a reentry permit, will create a presumption of abandonment of permanent resident status. This means that when you return to the U.S. after an extended trip, CBP officers at the port of entry will have the authority to immediately begin questioning whether you have maintained your ties to this country. If they determine that you have not, they can initiate removal proceedings right there at the airport. But here is the part that is truly alarming for frequent travelers. Even if you have never taken a single trip longer than 180 days, you can still be flagged. If your cumulative travel pattern over a rolling 36-month period shows that you have spent more time outside the United States than inside, the new law includes an automated tracking system that calculates your total days abroad versus your total days physically present in the U.S. If your ratio falls below 50% presence over any 3-year period, you will be automatically flagged for enhanced scrutiny. Regardless of how short your individual trips have been, this is a complete paradigm shift in how continuous residence is evaluated. The second major change involves the reinstatement and strengthening of the public charge rule. With new enforceable standards, the public charge concept has been part of immigration law for over a century, but its enforcement has varied dramatically. Depending on the administration, the new law codifies a significantly broader definition of public charge. That includes not only cash welfare benefits, like temporary assistance for needy families, but also extended use of Medicare SNAP benefits, commonly known as food stamps. Section 8, housing assistance, and certain other non-cash public benefits. If you are a green card holder and you have received any combination of these benefits for more than 12 months within any 36-month period, USCIS can now consider you inadmissible if you apply for naturalization or if you ever need to renew your green card. Most significantly, this provision applies retroactively, meaning benefits you received years ago can now be used against you in future immigration applications. The third major change is the introduction of mandatory biometric reporting every 5 years for all lawful, permanent residents starting immediately. Every green card holder must appear at a USCIS application support center once every 5 years to provide updated fingerprints, a photograph, and a signature. This is in addition to any biometrics you provided when you first obtained your green card or when you renewed it. The purpose of this new requirement, according to official DHS statements, is to maintain accurate identity records and to ensure that green card holders remain in compliance with their status. Failure to comply with this new biometric requirement within 90 days of receiving your notice will result in your green card being declared invalid, and you could be placed in removal proceedings. The fourth major change expands the list of crimes that trigger mandatory consequences. For green card holders under the previous framework, immigration judges and USCIS officers had some discretion in evaluating how certain criminal offenses would affect a green card holder's eligibility for naturalization or their risk of deportation. The new law significantly reduces that discretion. It expands the definition of aggravated felony to include additional offenses and lowers the threshold for what constitutes a crime involving moral turpitude. Perhaps most significantly, the new law requires USCIS to automatically review the complete criminal history of every green card holder who applies for naturalization if any disqualifying conviction is discovered, even one from decades ago that you thought was behind you. Your naturalization application will be denied, and removal proceedings may be initiated. The fifth and final major change involves mandatory address and status reporting, with real consequences for non-compliance. Under the previous rules, green card holders were required to notify USCIS of any change of address within 10 days, but enforcement was minimal and penalties were rarely imposed. Under the new law, the address reporting requirement is now strictly enforced. Failure to update your address within 10 days is now classified as a misdemeanor criminal offense punishable by fines and potentially even incarceration. Additionally, every green card holder must now carry their valid green card at all times when they are in the United States. Failure to produce your green card upon request by an immigration officer can result in civil penalties, starting at $250 for the first offense and increasing with each subsequent violation. Now that you understand the 5 major changes, let me tell you exactly what you should do right now. To protect yourself, I am going to give you 5 concrete action steps that you can begin taking today. First, locate your physical green card and verify that it is valid and not expired. If your green card is expired or will expire within the next 6 months, file Form I-90 to renew it immediately. Do not wait. Processing times are increasing, and under the new law, having an expired green card is taken far more seriously than it was before. Second, log into your USCIS online account or create one if you do not have one already. Verify that your current address is correct and matches what USCIS has on file. If you have moved at any point in the past and did not file Form AR-11 to report your address change, do it today. This takes 5 minutes online and could save your status. Third, gather and organize documentation, proving your continuous residence in the United States for at least the past 5 years. This includes federal and state tax returns, utility bills, lease or mortgage documents, bank statements, employment records, health insurance statements, and any other evidence showing that you have been living in the U.S. and maintaining ties here. Put all of this in a secure folder that you can access quickly if needed. Fourth, review your travel history. Carefully look at your passport, stamps, and any other records you have of international travel. Calculate how many days you have spent outside the United States over the past 3 years. If your presence ratio is approaching or below 50%, you need to seriously consider limiting your international travel and remaining in the U.S. for an extended period to rebuild your ratio. Fifth, if you have any criminal history at all, even a traffic ticket, even a minor offense from many years ago, Do not apply for naturalization or take any immigration action without first consulting with a qualified immigration attorney. The new laws, expanded criminal bars, and mandatory review requirements mean that applying for citizenship, when you have unresolved issues in your background, could trigger consequences you never anticipated. Let me share a real-world example that illustrates exactly what is at stake under this new law. I recently worked with a green card holder named Teresa, who has lived in the United States for 18 years. She works as a nurse, pays her taxes, has never been in trouble with the law, and has always followed the rules. But Teresa's mother in the Philippines became seriously ill last year, and Teresa spent 8 months there, caring for her before she passed away. When Teresa returned to the U.S., she was allowed through customs without issue, because the previous system gave officers discretion. Under the new law that was just signed today, Teresa's 8-month absence would trigger the presumption of abandonment. She would be pulled into secondary inspection, questioned extensively about her ties to the U.S., and potentially placed in removal proceedings unless she could provide overwhelming evidence that she had not abandoned her permanent residence. This is the new reality we are all living in. I also want to address something that I know is causing anxiety for many viewers, the question of whether you should accelerate your plans to apply for citizenship. The answer depends entirely on your individual circumstances. If you are already eligible for naturalization, if you have been a green card holder for 5 years or 3 years, if married to a U.S. citizen, if you have met all the residency and physical presence requirements, and if you have no issues in your background that could trigger problems, then yes, applying for citizenship is generally advisable, because citizenship provides the ultimate protection. Once you are a U.S. citizen, you cannot be deported except in extremely rare cases involving fraud in the naturalization process. However, if you have any complications, extended absences, receipt of public benefits, criminal history, tax issues, then you need to consult with an attorney before filing. Applying for citizenship when you have problems in your background can sometimes make things worse by triggering a review that would not have happened otherwise. I know this is a great deal of information to absorb. I know it feels overwhelming, but I want you to know that you are not powerless. The fact that you are watching this video right now means you are already ahead of millions of green card holders who have no idea these changes are coming. Knowledge is protection, preparation is protection, and you now have both. As we come to the end of this video, I want to remind you why Immigration News Today exists. This channel is here to protect you from being blindsided by changes like this. I will never sugarcoat the truth, but I will also never leave you without direction or hope. There are always steps you can take. There are always ways to protect yourself, and I will be here every single day to guide you through whatever comes next. If this video helped you understand the new immigration law that was just passed and what it means for green card holders, please do 3 things for me. First, like this video so more people can find it. Second, share it with every green card holder you know, your family, your friends, your co-workers. Third, subscribe to Immigration News Today and turn on notifications so you never miss an update. I am monitoring this situation around the clock. And the moment there is any new development, any guidance from USCIS, any court challenge, you will hear it here first. Before I go, I must give you my standard disclaimer. Everything I have shared today is for general, informational purposes only. It is not legal advice. Immigration law is incredibly complex, and your individual situation may have unique factors that require professional evaluation. Please consult with a licensed immigration attorney or accredited representative for advice specific to your case. Always verify information with official government sources, including the USCIS website. The DHS website and the Federal Register policy can change, and the information I have provided is accurate as of date. Thank you for trusting me with your time and your future. You have worked too hard for your green card to lose it because of a law you did not understand. Together, we will make sure that does not happen. My name is James, and this is Immigration News Today. Stay strong, stay informed, and I will see you in the next video. Take care of yourself and take care of each other.